everyone. It's Friday, December 13, 2024, 10 o'clock. I want to welcome everyone to one of our regular State Ethics Commission meetings. I'm going to jump right into before I jump into the agenda, we have a new commission member with us here today. This is her first meeting. Ms. Nancy Denson has been appointed a member of the commission. Commissioner Denson, would you like to say anything this morning?
Well, since I never give a politician a microphone, so would you like to say something?
But anyway, I'm Nancy Denson. I live in Athens, Georgia. I've been there most of my life. I consider myself a Georgian. And I was in elected office for 40 years. And so I think the governor felt sorry for me and said she can't just stay at home. So, and I knew Governor Kemp from the time he was a tiny little child. So he probably, he doesn't even remember the first time he knew me. But anyway, I appreciate being appointed to this board, and I think it's a very important board, and hope to be an asset. Thank you.
Thank you very much. All right, now we'll go ahead and jump into the agenda. It looks like we've got an agenda with 12 parts. Is there anyone with the staff that would like to identify any points on the agenda that need to be changed and incurred? Mr. Amati?
Okay, there we go. Section 3 preliminary hearings, item C will be removed and item E will be removed from this agenda.
Okay. So we would just, for preliminary hearings, we'll have A, B, and D, is that right?
That's correct.
Are there any changes to the consent orders?
I don't believe so, no, sir.
All right. Any other changes from anyone on the commission staff?
No, sir.
Okay. Thank you, Mr. Amati. With those changes in the agenda, I'd like to go ahead and move that we adopt the agenda as amended.
So moved. For second.
Got a motion and a second. Any discussion? All in favor say aye. Aye. Any opposed? All right, so the agenda is approved. Let's go ahead and move then to the review and approval of the meeting minutes from the last meeting. The last meeting was actually all the way back on June the 17th of 2024 because we had a cancellation of the last regular meeting due to weather pretty much all over the state. Have those that were present for the meeting on June 17th of 2024 had an opportunity to review those? All right. Does anyone have any changes or any issues with those minutes as they're presented? All right, I'll go ahead and make a motion that we adopt those minutes from the June 17, 2024 meeting as presented. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the vote. All in favor say aye. Aye. Any opposed? All right, those will be approved. Let's go ahead and move into the preliminary hearings. First case that I will call is 3A on the agenda. It's case number 24-0054-C in the matter of Nicole Jones and committee to elect Nicole Jones for Superior Court Judge. Mr. Knittel, I understand that this is your case, and I did see in our handout folder a letter that was included. It looks like it's dated December the 10th, and it was from Nicole Jones, and it looks like it's a conflict letter. Is that right?
Yes,
Which one is it? All right, we're good.
yes, that's correct, and if I may, that we did receive a conflict notice from Ms. Jones on the 10th of December. Related to that conflict, our office reached out. There were 2 cases that she had listed that were criminal cases appearing before Clayton County Superior Court Judge Garanda Carter. We contacted Judge Carter's office, and we were informed that those cases were not being called in this week. I believe it was a two-week trial calendar. So the conflict that would have existed for today no longer exists. And I sent an email to Ms. Jones on December 11th at 1:27 in the afternoon, letting her know that information and that I would be opposing that request for continuance because the conflict, as I stated before, doesn't exist anymore.
When was Ms. Jones provided notice of the preliminary hearing that we were gonna have here today.
I believe that was November 20th, 2024.
And it looks like the conflicts that she identified here were for the weeks of December 9th and December 16th. So she actually sent the conflict letter after, when she says the conflict began, is that right?
That is correct.
Okay. And you have reached out and confirmed that those cases that she identified would not be going forward?
Yes, specifically with the judge that was presiding over those matters. The judge, assistant indicated those cases will not be called in this week.
And what day was that?
That was on December 11th.
Okay.
The very next day, as soon as we received the information, we contacted the court and determined what was happening with it.
All right. As a procedural matter, Mr. Knittel, or Mr. Amati, do we need to actually take a vote on the issue of the notice of conflict before we actually proceed with the preliminary hearing?
No,
Mr. Amati?
no.
Okay. All right, Mr. Knittel, go ahead and move forward if no vote is required.
Yes. This is the matter of Nicole Jones, and the committee to elect Nicole Jones for Superior Court Judge. It's case 24-0054-C. I believe there's been a summary provided to the commission on this particular case. But some of the background, did you want me to go through the summary?
No, sorry.
Yes.
I didn't ask if anyone was actually present here today with respect to this case. All right, I don't hear from anyone. Are we still streaming these? All right, there's no one that's present out there waiting to speak on any cases at this point?
Isn't it true we stream it, but we don't allow them to participate?
That is correct.
Gotcha, okay. So no one's present here for that case. Do we have any issues again with regard to notice? I think you've already touched on that.
So I will say this about notice, Mr. Chair. There has been, we've sent notice to, I believe it's 3 different addresses multiple times. This was on for a hearing prior to today's date, and we continually have the same issues, where sometimes we'll get the packages back, other times we will not. However, Ms. Jones has confirmed receiving this information in an email.
Well, she had to confirm it in this case because she
Yes.
knew to send a conflict.
So yes, so she knows about the case, but I just want to put on record that we've had great difficulty with the addresses she's provided in serving her notice.
Mr. Amati?
And to clarify something that the vice chairman said, we do stream these live for the public to watch. But if a participant, a respondent wants to litigate the matter, we require them to come in person. But this is available for the public at all times.
Okay, Mr. Knittel, go ahead. Sorry about that.
No, thank you. So Ms. Jones was a candidate for Superior Court, Douglas County Judicial Circuit, McLean. That was the judge's seat that was coming available for the 2024 election cycle. She did file a DOI on February 14th of this year, and then she qualified on March 4th of this year. She did have there was a primary, and she was successful in that she went into a runoff election. The runoff election held on June 18th, she was not successful in that. Procedurally, this case was originally filed by commission staff on May 9th of this year, and there were additional allegations filed on those dates that are listed there as we determined additional information about this case. A subpoena was issued requesting campaign records, and complainant did provide via email bank records on June 14th of this year. But essentially this case, we allege the following violations. There were 5 CCDRs that were failed to file, 1 PFDS failed to file, and then also she failed to keep a separate campaign depository account. As I stated already, respondent had confirmed via email that she had received the original complaint. The other information that Ms. Jones provided back to me via email, there was, I'm just going to describe it as how I see it, was basically an Excel spreadsheet that had some purported contributions and then some expenditures. And it was very limited information on that. Short of that, there really hasn't been much additional response by the respondent. The first violation is a violation of failure to file the PFDS, personal financial disclosure statement, within 15 days of qualifying. It's violation 21-550. This slide essentially just shows when she did in fact qualify. This is from the Secretary of State's office. She qualified on March 3rd, 2024. And so within 15 days, PFDS is required to be filed. This is just a screenshot taken in time when the complaint was originally done, showing that there is no Nicole Jones with the PFDS in our system. And so she did not file within the applicable periods, and so it's a violation. She needed to file for covering calendar year 2023. She did not do that. It's a violation 21-550. With relation to filing campaign contribution disclosure reports, the commission knows well the election year cycle as to what's required. And also there's in this case there was a runoff, so there's an additional requirement there that CCDR be filed within 6 days of any runoff or primary. Ms. Jones did file a DOI and a registration of her candidate campaign committee with our office on February 14, 2024. There have been no, in this campaign, there have been no CCRs filed by her. This is just a screenshot from our e-filing system. On her summary page, it shows 0 contributions, 0 expenditures. And the reason I'm pointing it out to the commission is that these are different screenshots of items we were able to locate related to her campaign, obviously spending campaign funds related to her campaign. She has flyers, she has door knockers, she has a bunch of signs. I believe with, there were a couple, it was either half-page or full-page ads taken out in a Hometown Advantage advisor. We followed up with that newspaper, and that full-page ad cost almost $1,000. There's a copy of the ad right there. We also just, we happen to have an individual that works in the commission that lives in Douglas County, so I asked him to just kind of purview the county, and just without, extensively going through everything, counted more than 25 4x4 foot signs, which are, those are rather large signs, and you can see them multicolored. More than 100 standard yard signs he was able to count. This is just showing that she did advance from the primary election to the June 18th runoff. And so ultimately what we're left with is for CCDRs, there are 4 CCDRs, regular calendar year, April 30th, June 30th, September 30th, October 25th, 2024, that she failed to file. And then she also failed to file her June 18th, 2024 primary runoff CCDR. Those are all the first 4 CCDRs in violation of 21-534C2A. And for failure to run off to file the primary runoff is a violation of 21-534C2B. The last matter that we allege that Ms. Jones violated, that her campaign violated, is she did not keep a separate campaign depository account as required. This is the letterhead from her first conflict that she filed in June. And I'm only showing this to point out that, because I'm going to show you bank records that she provided, it has the exact same address. It shows Jones Federal and Appellate LLC, which is not her campaign account. These are the bank account records that she provided to our office in response to the subpoena. Shows that this belongs to her law firm. It's not a campaign account. Again, February and March. And then in this one, in the April 2024 bank statement, there is a, let's see if I can make this larger. I can't, okay, being told I can't make it larger.
So let me ask you this.
Yes.
You know how much I really enjoy PowerPoints,
I know.
because you can't see anything.
Was this included in the commission packet? Because I'm not seeing it in the commission packet, and if not, can you, because I can't read that, can you tell me through your egregious subpoenas, because you guys like to subpoena everybody, you know how much I like that too, how much you saw in the bank account records that you think are part of the campaign?
Yes,
And is this is a bank statement, not a credit card, right?
correct, this is a bank statement. So there was approximately, let's say, $6,000 to $7,000 that I saw through the bank account statements that she provided. And I apologize that you're not able to see this, but in this particular one from April, there is a payment made to one of the companies that in the Excel spreadsheet that she provided is the same company. So within this bank statement, I would correlate that to being a campaign expenditure. Yes, sir.
So I know you'll get here, but maybe I hope. The violations that are stated in our packet just talks about disclosure reports not being filed. Would there not be additional violations for expending the money and not listing it? There's a violation for not filing it, but also not reporting the expenditures and contributions. Shouldn't they be itemized? Because I know we've gotten into this posture that we vote specifically on what a administrative law judge can hear. Would we not want those included?
Those, you're correct, those could certainly be included. Yes, you're correct on that, those could be included. In this particular matter, we got very limited response on the subpoenas. And yes, I could have certainly included in that, perhaps I should have, I did not in this case, because we had 0 filings of the CCPRs. And I think those we can address with her.
But you're not gonna be able to take it up. I mean, if we vote on it, isn't how we've always done it? I mean, recently done that. We can't expand it. So if when the AG gets involved or the administrative law judge and you get additional information, if we don't put it down now, am I wrong? We can't bring it up at OSA. Is that what we've done in the past?
The only-
Yeah, I think that Commissioner makes a good point in that I think if it's something we have information on now where we could charge certain violations, you can't add to that going forward. Now, if she continues to, violate the Campaign Finance Act in some form or fashion, after a preliminary hearing here today, that can be brought up with an additional complaint, right?
That is correct. And I would like to say with regard to the bank records, the only expenditure there's a single expenditure that I can point to, that I can say with some certainty, that was a campaign expenditure, and it's based upon this spreadsheet she provided me, where it shows a payment to one vendor. It was paid to, actually doesn't show on here.
I don't think that part matters. If you have one, you can say that she violated that part of the law, and if you find more, because right now we're just talking about a violation of her not filing a report, which is one fine. Each expenditure not reported would be another one, but if you don't list that in, the violations you want the commission to set forth here, then the way we've done it recently, we can't bring that up at OSA.
Mr. Amati?
That's correct. That's correct, just in case you didn't hear, Commissioner. We do have the right to amend complaints at future dates, and to the chairman's point, we're gonna have an additional violation, quite likely, based on past behavior in 17 days. So we can amend to add additional charges to bring before the commission before an OSA hearing is final.
I don't think you can amend a complaint to bring additional charges that you already had information on before the preliminary hearing. I mean, otherwise, I think at that point you've got some form of notice issue.
Are you talking about a brand new hearing on additional charges?
Yes.
Yes, now I agree with that.
That's what I'm saying. I'm saying we do have that ability at a future date to file additional allegations and have a new hearing addressing those on the same case number. And that has happened before.
Even as to allegations the commission had knowledge of before a preliminary hearing on other issues?
I don't think there's any issue of jeopardy attaching till an order's final, so I don't think a preliminary hearing precludes any additional violations that are out there.
Well,
Okay.
if we have the information, I don't know why we wouldn't just place it on this, take it up now. And if we, if you find more, then you're gonna catch it, underneath that violation, because you're talking about expenditures weren't reported or contributions weren't reported. So it doesn't matter if it's 1 or 50 you find.
Yeah, but again, that's where I was talking about, I think we're gonna run into notice issues. She doesn't have notice for this preliminary hearing for us to try to add any
Right.
charges to that.
Right.
She would have to know exactly
I
what
got you.
she's been charged with.
I got you now. I hear what you said.
But Mr. Vice Chairman, that's a fair point, that moving forward, if we're gonna charge failure to file X number of CCDRs, and even if it's just one expenditure that we do know of, we can file in that complaint, well, there was a failure to itemize this particular expense. That's a fair point as well.
I understand now. It's because what we listed to her
Is
is
what
the
she's-
only thing we can bring up.
Is what she's on notice of for today, correct?
My brain is so big and charges on it that we can't, I got it.
Okay.
Mr. Canoa, go ahead.
Thank you. And these are the spreadsheets you provided, so we can take a look at those at a different point if we move forward on additional in December. I know you can't see them, Vice Chair, I'm sorry. But essentially, she violated 21.530C by failing to utilize a separate campaign account for all deposits and withdrawals related to her campaign and violated the act of that manner. And there are reasonable grounds to believe that she violated the act in these three manners, 21.534, 21.550, and 21.530, in the manner for the CCDRs that she failed to file, including the primary runoff, failure to file a personal financial disclosure statement, and also failure to use a separate campaign depository account.
All right, I've got a couple more questions regarding all of these notices of additional allegations that went out to her.
Yes.
I was looking through these various notices that went out to her, and again, maybe this is to Mr. Amaji's point. I'm looking at that November 25th, 2024 notice of additional allegations that went out. Do you see that?
Yes.
And that's talking about, again, it looks to me like we went backwards there, right? Because that's talking about a violation as of June 18, 2024, correct?
Yes, that was related, I believe, to the primary CCDR.
Right. And then even when you go back to November 1st, that notice that went out to her, those were for violations relating to September 30, 24, and October 25th, 2024.
Yes.
So again, when we went back and added the one from June, to Mr. Amati's point, we were, going back and adding allegations that weren't necessarily there, before.
They were not part of the original complaint, that's correct.
That's right, but even beyond that, what I'm saying is the timing, went backwards to some degree, because we sent notice of additional allegations for September and October, but then went back on the next one and put an additional allegation in there for June, which would have been before those other two. Am I
Yes.
making any sense at all?
Yes, I understand.
Well, how about that now? He can say it a little bit better.
So I think this makes it a little clearer. As long as there's not a final order and the statute of limitations has not run for a particular violation, we can add those allegations at any point in time.
I agree.
I think that's the cleanest way to explain that.
This has a 5-year statute of limitations because it's a 4-year office.
Is there anything else you can say about me before we move on?
Sounds good for now.
All right.
With that, I submit that to the commission.
All right. Are there any questions for Mr. Knittel with respect to this particular case as it exists at the present time?
I have one. Just because of the notice and the letter we received, each of our hearings has its own notice requirements, I get that. But this case was on the docket for our Savannah meeting that was canceled because of the weather. So this has been around
Yes,
as well. So this is not new.
Correct.
Is the point I'm trying to make. Now, obviously, if she has a conflict today, that's a standalone issue, but this is not something we sprung.
correct. In fact, with the conflict that she had in June, I simply agreed to it because those cases in fact were going to be in court. and
Right.
To the best that we knew. So I didn't even bring it before the board. So,
Okay. Any other questions or comments from the commissioners before we move further on this one? I'll go ahead and make a motion then that reasonable grounds exist, that the respondent violated the Campaign Finance Act by failing to file April 30, 2024 election year CCDR in violation of OCGA 21-5-34C2A. Do I have a second?
Second.
Got a motion and a second, any discussion? Hearing none, I'll call the question, all in favor say aye. Aye. Any opposed? Motion passes. I'll make a motion that reasonable grounds exist that the respondent violated the Campaign Finance Act when she failed to file June 30, 2024 election year CCDR in violation of OCGA-21-5-34C2A. Do I have a second?
Second.
Got a motion and a second. Any discussion? Go ahead and call the question. All in favor say aye. Aye. Any opposed? That motion passes. We'll go ahead and make another motion that reasonable grounds exist that the respondent violated the Campaign Finance Act by failing to file September 30, 2024 election year CCDR in violation of OCGA 21-5-34C2A. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? That motion passes. I'll make another motion that reasonable grounds exist that the respondent violated the Campaign Finance Act by failing to file October 25th, 2024 election year CCDR in violation of OCGA 21-5-34C2A. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Sorry, I didn't hear. Motion passes. I'll make a motion that reasonable grounds exist that the respondent violated the Campaign Finance Act by failing to file 2024 PFDS covering calendar year 2023 in violation of OCGA 21-5-50. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. We've got one more motion in this case. That reasonable grounds exist that the respondent violated the Campaign Finance Act when she failed to file, or actually failed to utilize a separate campaign account in violation of OCGA 21-5-30C. I've got a motion. Do I have a second?
Second.
A motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries.
Mr. Chair?
Yes, sir.
One item, and I apologize, I did not have it on this particular summary. It was for the runoff CCDR for failing to file the June 18th, 2024 primary runoff, and that's OCGA 21-5-34C2B.
I thought that's number 5 on your slide.
It's on the slide, but I don't know, it's not on the summary sheet. I simply missed that on the summary sheet.
And that was addressed in your presentation, right?
Yes, it was.
All right, I'll make one more motion then. I'll make motion that reasonable grounds exist that the respondent violated the Campaign Finance Act by failing to file June 18, 2024 CCDR in violation of OCGA 21-5-34C2B.
Yes.
All right, got a motion, any second?
Second.
Got a motion and a second, any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. Thank you, Mr. Knittel, for keeping track of that. That's a good thing. And again, for any ongoing violations, additional violations that are uncovered, that can be handled in an all-new case, right?
Yes, that's
Okay.
correct.
All right. next preliminary hearing. It's 3B on the agenda. It's case number 24-0087-C in the matter of Grace DeMitt. Is anyone present here today with respect to that case other than Mr. Knittel? Don't see anyone. Mr. Knittel, do you want to go ahead and proceed?
Yes, thank you. In this case, 24-0087-C, Ms. DeMitt qualified for the primary election for State House District 49 on March 8, 2024. She filed her DOI on April 17th of this year, and she was a candidate for the Democratic primary election for State House, which was held on May 21st, 2024. She advanced from the primary election and to the general election, and she was unsuccessful in general election on November 5th this year. Procedurally, this complaint was filed by Commission staff on August 12th, 2024. There was a notice of additional allegations filed on November 19th, 2024. A subpoena was issued in August with a return date of September 12th of this year. There's been no response to the subpoena. And the Commission, we've alleged the following violations of the Act. There were 3 CCDRs, election year CCDRs, that she failed to file, and a personal financial statement. She failed to file that as well. There's been no response by a respondent. She has been sent notice per our regular course of business, but simply hasn't responded to anything. So the first violation I'd like to address is the 21-550 for failure to file her personal financial disclosure statement within 15 days of qualifying. This slide just indicates and shows her qualifying date was March 8th, 2024. That's with the Secretary of State's office. And this is a screenshot from our system, our e-filing system. It shows there's been no personal financial disclosure statement filed. And I checked that this morning, there still is no PFDS filed. And so she failed to file that in violation of 21-530. It would have been covering calendar year 2023.
30 or 50?
21-550, I'm sorry, I misspoke. With regard to campaign contribution disclosure reports, those need to be filed on 6 different time periods during election year, unless there's a runoff campaign, of course. What's interesting about this one is that she did in fact file on April 30th, 2024 CCDR. However, and you may not be able to see that, Mr. Thompson, but she filed all zeros. So she was able to access our system and file CCDR, but it has no contributions, no expenditures.
Even though that's not in our packet, what else did the contribution disclosure report say? For the reason for late filing? Was there,
No, she filed within the grace period.
on her CCDR, I just looked up, it says reason for late filing, and she claims to have had problems being able to access the system.
She may have had problems and spoke with somebody in her office, but eventually she was able to get it filed. It was filed on May 7th. On the bottom of that. This April 31.
Just what it says.
Okay.
All right, I feel like I always got to clarify here when the vice chairman speaks. Mr. Lottie, can you say it better?
I'll try. So the vice chairman's correct. The lone CCDR she filed is the April 30th one, correct?
That is correct.
And she does have an addendum that said she filed it and she had a reason for filing it late, which was technical issues. But in reality, she was not late. She was within grace.
Yes. So,
Excuse me. I have a question, and it's probably out of order right now.
Now,
Nope.
I'm having to get my feet under me. What are the enforcement vehicles that this committee has if fines are assessed and then not paid?
So in the event a fine is issued and the individual responsible refuses to comply, we work with the Attorney General's office, and they have a division that, for lack of better phrasing, we go to the Superior Court of their residence, that home county, and file a garnishment action against their wages. And we've had to do that in the past.
And again, just to add to that, that all we do at this point is find that reasonable grounds exist. That gets the case, to the AG's office. They then go ahead and pursue that in the Office of State Administrative Hearings. And it's the judge there that actually decides on what fine to impose. And then the case comes back to us, what is it, for action within
30 days.
within 30 days. If we take action within 30 days, that's one thing, but if we don't, it's automatically completed at that point. We don't have to actually act on it to affirm it or anything like that. Is that clear?
I couldn't do it any better.
Thank you.
Mr. Cannittle?
Thank you. And so, no other CCDRs have been filed since that April 30th CCDR that had all zeros on it. These are just some of the campaign exhibits that we're able to locate. Where you can see she has some signs. Clearly, the one on the right might be difficult to see from your position there, but it's, asking for contributions. Again, these are, she appears to have, the standard sign that, yard sign that folks have. Along with other matters, she's to raise money and spend money. On the right, there is that was posted on May 20th. I know you can't see that, Vice Chair, but it was posted on May 20th, and that's letterhead for her campaign. So clearly expenditures were made. And in fact, even if she didn't make any, she's running for State House, she needs to file her CCDRs. But just showing, it does appear that she did expend campaign contributions. Again, this is just another way for people to contribute to her campaign. And so we have 3 violations in 21-5, 34C2A. That's for failing to file her election year June 30th, September 30th, and October 25th, 2024 CCDRs. And so all in all, there's reasonable grounds to believe that she violated the act in those 3 ways, and also for failure to file her personal financial disclosure statement as required within 15 days.
Was this our first experience, running for office and making filings with us?
I believe so. I don't know that definitively, but I believe so.
Any questions or comments for Mr. Cannittle?
And I just like to point out, she actually did win her primary, and she advanced, she had primary contest, and she actually advanced from that, went to the general, so.
We're not charging anything on the April 30th. All
No.
through, that just,
She indicated zeros. I don't have any financial records otherwise to dispute that.
okay,
It's
so
kind
that,
of surprising, but that's what she indicates. So
but those are the ones she didn't file.
that's the one she
Gotcha,
filed.
thank you.
Did you say you subpoenaed her bank account?
I don't know what bank she uses. We send subpoenas to the campaign and her campaign
Okay.
committee if we don't have any idea who she's using.
And there was no response to that?
Correct. And I think this was also on the prior meeting, I'm looking to Mrs. Within the council meeting that we had in September, this would have been on that meeting as well. So this is also similar, like the last case been around for a little bit. And that's why there's additional allegations.
Right, that's what I was gonna say. I mean, with respect to her,
Mhm.
because we didn't have that other meeting, she ended up with further,
Yes.
allegations against her.
Mhm.
Yeah, okay. Anything else from any of the commissioners on this? Well, I guess y'all want me to go again. If anyone else wants to do this, all you gotta do is let me know, but I'll go ahead and make a motion that reasonable grounds exist that the respondent violated the Campaign Finance Act by failing to file June 30, 2024 election year CCDR in violation of OCGA 21-5-34 C2A. I got a second?
Second?
Got a motion and a second, any discussion? Hearing none, I'll call the question, all in favor say aye. Aye. Any opposed? Motion carries. Make a motion that reasonable grounds exist that the respondent violated the Campaign Finance Act by failing to file September 30, 2024 election year CCDR in violation of OCGA 21-5-34 C2A. Do I have a second?
Second?
Got a motion and a second, any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. Make a motion that reasonable grounds exist that the respondent violated the Campaign Finance Act by failing to file October 25th, 2024 election year CCDR in violation of OCGA 21-5-34C2A. Do I have a second?
Second?
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? That motion carries. Make a motion that reasonable grounds exist that the respondent violated the Campaign Finance Act by failing to file 2024 PFDS covering calendar year 2023 in violation of OCGA 21-5-50. Do I have a second?
Second?
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. Mr. Canitto, are there any additional grounds that need to be addressed?
No, sir.
Okay. Thank you very much. Go ahead and call this case, this one's not yours though, Mr. Babel.
Yes, sir.
We're doing D. Going to go ahead and call the case on 3D on the agenda for the preliminary hearings, 24-0069-C in the matter of Joe Ray Jenkins. Is anyone present here with respect to that case other than Mr. Baywall? I don't hear of anyone. Mr. Baywall, go ahead and proceed.
Okay, good morning to our board members. This is the matter of Joe Ray Jenkins, case number 24-0069C. The violations that I'll be presenting to the board today: violation 1, the respondent failed to timely file her calendar year 2023 PFDS in violation of OCGA 21-5-50A. Violation 2, respondent failed to timely file her April 30th, 2024 election year CCDR in violation of OCGA 21-5-34C2A. Violation 3, that respondent failed to timely file her June 30th, 2024 election year CCDR, also a violation of 21-5-34C2A. Violation 4, that respondent failed to open and maintain a campaign depository account in violation of OCGA 21-5-30C. And lastly, that respondent failed to report campaign contributions and/or expenditures in violation of OCGA 21-5-34B. Procedural background: Ms. Jenkins was a candidate for Augusta, Richmond County District 1 Commissioner in the 2024 election cycle. She filed her DOI on March 8th, 2024. She also qualified for office on that same day. She was later the unsuccessful candidate after the May 21st, 2024 primary election. This complaint was generated by the commission on May 28th, 2024. We've also served additional allegations on Ms. Jenkins on July 15th and September 5th, 2025. Candidate has received notice of the complaint. She's also received notice of this board meeting. I've talked to her numerous times about both the complaint and also about the preliminary hearing here today.
When did you last speak with her about this?
Within the last week, she asked me just for the address, date, and time of the board meeting, and then I resent the notice. She contacted me over email. So the notice originally went out to the address she used to register. It is a good address. She's gotten everything up to this point. She asked when the day, date, and time for the preliminary hearing was over email, and then I emailed her back the response showing the day, date, and time of today's hearing. And it was discussed with her on the phone as well. I've talked to her at least 10 times during this complaint. First thing that I did want to draw your attention to, and this is something that we got from the local Board of Elections, but when we initiated the complaint, as part of our investigation, we got all of her qualifying paperwork. The Richmond County Board of Elections, they provided everything that she received. Specific to that was a checklist where they advised her, all the forms that she's getting. She's advised that she has to file a PFDS within 15 days of qualifying. She's advised that she has to file the April 30th CCDR. She's advised of the grace period. She checks off everything that she receives, and she signs the document. So the fact that she had to file a PFDS or a CCDR should not have been foreign to her. The next document.
I haven't seen many of those. Is that something that we're getting routinely? Or is that just something that was specific to that county?
This is just Richmond County. I think just in interacting with him, I think they do a fantastic job. And I've actually talked to him and encouraged him, because whenever we get a complaint, it's pretty common that somebody says, well, I talked to somebody at the Board of Elections and they told me I didn't need to file this, and it turns into an argument of who said what, and ultimately we'll consider, if somebody's given bad information, but ultimately it's on the candidate. But in this particular scenario, I think Mr. Doss is the gentleman's name in Richmond County. He's doing a very good job, and I did tell him that, and I think it's something other counties should pick up on.
Yeah, I think we should, during whatever kind of training sessions we have or something, I think we should urge other local folks to be doing that, because it's a great piece of evidence.
Or we could pass legislation where all the local filers are back with the commission where they belong.
Wait an hour and we'll get to that.
But no, in all seriousness, I think that's something great that these local folks, can do, short of everything being, returned to the state level. So anyway.
I agree. Next document that I'm showing you, this is a notice of late fees and automatic late fee increases. Typically, we'll receive notice from the locals that somebody has been late on filings. In Ms. Jenkins' case, it was the April 30th CCDR and her calendar year 2023 PFDS. We try, in situations like this, you can see the late fees are only $250. We have a staff member in-house who notifies candidates of the late fees, and they also get a notice that the late fees are going to increase if you go a specific period without filing these things. This was sent out by Ms. Benson. We prefer to handle a lot of matters like this, where it's just 2 missed filings and they're only a few weeks tardy, because they can pay the late fees. We don't have to go through the resources of filing a complaint. So this was sent out to Ms. Jenkins by email. She responded back to Ms. Benson, no answer, and made no other indications that she was interested in filing, gaining compliance, or paying the late fees. So at that point, Mr. Cusack was still here. He assigned the case to me. The applicable law, violation 1, OCGA 21-5-50A. This is the law for filing a PFDS. Subsection 1 of the statute applies to specific public officers, but essentially anybody who's in office has to file a calendar year or a PFDS for the previous calendar year by July 1st. In addition, if you're a candidate for public office, you have to make that filing within 15 days. Subsection 3.1 of the statute binds that same law on local public officers. So this is the law that required Ms. Jenkins to file a PFDS within 15 days of qualifying for office. Violation 2, the applicable law, violations 2 and 3, OCGA 21-5-34C2A. This is just the general filing schedule. When you file the DOI, you have to make these election year filings: January 31st, April 30th, June 30th, September 30th, October 25th, and December 31st. And then in this particular case, the missed filings were April 30th and June 30th. Violation 4, OCGA 21-5-30C. This just puts a statutory duty on the candidate. Under subsection B, they have to maintain records and file reports under subsection C, they have to open and maintain a separate depository account for contributions that they receive. The last violation we're alleging here, OCGA 21-5-34B, this just essentially, this statute reduces down the following. When you run for office, you have to report all your contributions and expenditures. If it's a contribution of over $100, there's specific things you need to report. If it's a contribution, or if it's an expenditure over $100, there's specific things you need to report. If it's less than $100, you still have to report your total contributions. And the way you normally do that is you'll distinguish between non-itemized contributions or expenditures, and those are under $100, and contributions and expenditures exceeding $100. But this all boils down to every dollar that comes in, every dollar that goes out, it has to be reported on the corresponding CCDR. The evidence in this case for violations 1, 2, and 3, Richmond County uses the Easy Vote filing system. This is a printout of all the filings that she has on file, and you can see that the June 30th and April 30th, 2024 CCDRs, they were finally filed on August 2nd of 2024. So that would be the evidence showing that those two reports were late. The personal financial disclosure statement, this was filed on September 12th, 2024. That's the evidence that that filing was made late. Violations 4 and 5, and this is the not having a separate depository account and also not reporting contributions and expenditures. Just some background, because this is evidence, the conversations that I had with Ms. Jenkins when this case initiated. I talked to her within a few days of the complaint going out, and I got general information about her campaign. She told me that up to that point, this is a phone conversation I had at the end of May, she had told me that she had a few $100s in contributions. She said she didn't really have an active campaign. She was going through some things personally. So what I told her is I said, well, you have to file the April 30th CCDR, and you're going to have another filing due June 30th. I gave her general information on, you have to report all contributions and expenditures. Anything over $100, you have to report this way. Anything under $100, you can just total and aggregate and list that as non-itemized. So when I talked to her early on, she did indicate to me that as of May 2024, she had some campaign activity. Whenever we do an investigation, we'll also look on social media to just try and get a flavor for their campaign. Google's a great resource. You can see if people have websites. You can look on Facebook or social media. You can see if people are wearing t-shirts. Are they printing off yard signs? Are they doing bumper stickers? So that was done at the beginning, and I had kind of a general idea, some of the things that appeared to be campaign contributions or expenditures early on.
Commissioner Thompson?
So, going back to the evidence part of it, what is your evidence she doesn't have a bank account?
Okay.
Okay.
So early on, this is what I knew early on. I knew she had a smaller campaign. I knew what I saw on social media. So I encouraged her to make her CCDR filings. So the April 30th, 2024 CCDR, this was filed on August 2nd. This is a copy of the summary page. She lists one contribution of $350, one expenditure of $350. The date of the contribution she's listing as July 17th, 2024. The date of the expenditure she's listing as May 5th, 2024. So naturally, when I look at this filing and I say, well, wait a second, you told me you had contributions in May. I don't see anything reported in May. You told me, or I'm looking on social media and I see evidence of other spending and it doesn't appear on the CCDR. I'm going to show you also June 30th CCDR. This is just a zero report. So this is the entirety of what she's reported for her campaign. So after I made that review, She was working with a woman named Ornisha Brown, and I had talked to her throughout this quite a bit, but I basically said to Ms. Brown and Ms. Jenkins over email, I said, listen, I looked at your CCDRs, it appears to be some discrepancies. You told me that there was money coming into your campaign prior to May, I don't see any of that reported. I looked on your social media, and I'll get to the individual things that I saw on social media, but it looks like you have some t-shirts. It looks like you're doing some photography work or graphic design work, possible printing expenses. And these are things that I'm not seeing on the CCDR. I was talking with Ms. Brown pretty regularly. We had a very good exchange because I was trying to guide her on getting these things filed correctly. The last email that I sent to her and Ms. Jenkins, I said, does she have a dedicated campaign account? Because I need to see the financial records. That first email exchange occurred on August 16th, 2024. It went complete radio silence. And when I'm saying I probably had 4 or 5 emails with Ms. Brown that day where we were just going back and forth having a conversation. And then when I say, hey, there's some discrepancies, is there a dedicated campaign account? I need to see the records. Radio silence. I followed up again Friday, August 23rd, sent an email to Ms. Brown and Ms. Jenkins, same subject matter. Hey, there's some discrepancies. I need to see a dedicated campaign account. I need to see some financial records so I can confirm whether your CCDRs are accurate or not. I did not hear anything back until it was the first or second week in September. It was after I served additional allegations on Ms. Jenkins. She called in, she was upset, she was yelling at me. But that is when I calmed her down, we had a conversation. I asked for the bank records. She said she didn't have a dedicated campaign account. I have not received anything that would indicate that she does have one. So the evidence for count 4 is just me asking for these records, the absence of the records, and her telling me in September when I spoke to her on the phone that she didn't have a dedicated bank account. Count 5, the violations that she count 5, I elected.
Mr. Mayor, will hold up. I'm going to correct you if I may. I believe there is more evidence she doesn't have a campaign account, which is that in all of her campaign disclosure reports, there are no evidence of campaign bank fees, which if she had a campaign account,
That's not true.
she would have to pay them.
She should have. That's not true. I have many bank accounts that don't have bank fees.
When asked if she had a campaign account,
No, I understand that she told him no, she doesn't.
Okay.
I get that, and I'm fine with that.
okay.
My comment that maybe you didn't hear because I was trying to be quiet, is you asked me if I was satisfied. I said I'd be more satisfied if there was a statement, an official
I
statement
see.
from
Okay.
the commission staff that was a piece of evidence that we could review and actually see.
A signed affidavit by a staff attorney saying this conversation occurred.
I don't know that, it was afterwards.
Okay, I think evidence was just presented by staff.
All right, Mr. Baywell, go ahead.
And you can put me under oath, Mr. Thompson, and I don't have any crimes of dishonesty or other falsehoods that would make me incredible. But that's the information that we have. I will also add this too. This is a civil proceeding. It's administrative in nature. We've presented evidence that there's an absence of a bank account. And this is a scenario where if there were a fact finder listening to this, we'd ask for burden shifting because we're doing everything we can to get the information, and the reason we're not getting it is either because it doesn't exist or the person isn't turning it over.
Well, it's reasonable grounds at this
Yes.
point.
Yes,
That's where we are. I get it.
Yes.
Violation 5, and I don't have great specificity with contributions or expenditures that aren't reported. I'm just going on information that I see on Facebook. So the first thing that I see is the post that you see right here. This was posted on March 23rd, 2024. It looks like there's 2 people that are wearing Joe Ray Jenkins 2024 for commissioner t-shirts. I didn't see this reported on April 30th CCDR. I don't know if these were self-funded. I don't know if somebody made donations and they were purchased from the campaign. I don't know if an individual person gave them in kind to the campaign, but all I'm saying is that it appears that this is something that should be reported one way or the other on the April 30th CCDR, and it was not. The second slide appears to be some photography expenditures, graphic design expenditures, possible print expenditures. These are things that were just, put on Facebook, but these are typical business advertisements that appear. These are common campaign expenditures that candidates make. Same thing for this slide. It appears to be some photography contributions or expenditures, possible graphic design, possible printing. This is this candidate ran for Super District 9 Commissioner in 2020, and I just posted this. This just appears to be a contribution from her last campaign to her new campaign. So the picture on the left, that's what's showing her as advertisement from Super District 9. When you look at the picture on the right, it appears that there's some white over where Super District 9 is, so it's elect Joe Ray Jenkins District Commissioner, but this does appear to be a reused sign. Not that it's the crime of the century, but it is a contribution from the Super District 9 campaign to her current campaign. That's something that does need to be reported.
Where is that?
It's right, you can see, it looks like a little, it looks blurry.
Right here, and you can even, when you look close at this, you can see there's, I can make out an S right here, and U right there, but there appears to be white out here and white out here.
Yeah, okay, I got you.
The spacing also doesn't make any sense without additional workers.
Correct.
Right.
Correct. The last thing, this is a photo that was posted on April 23rd, 2024. Ms. Jenkins, now again, she reported one expenditure for yard signs. It was May 5th, but this is being posted on April 23rd, 2024. Purchasing signs, that's not usually something that's done on credit. That's usually something where a vendor is going to take payment of money before the signs are actually distributed. But this should appear on the April 30th CCDR, and again, it does not. I don't see, if she funded it or if she was raising money to fund it, I just don't have that information, but I do know there's no entries on the April 30th CCDR corresponding to signs that would have been purchased prior to April 23rd, 2024. So that's the presentation I have for the commissioners. And again, the 5 violations listed, I'm asking the board to find reasonable grounds on each of those 5 violations.
Mr. Baywell, I was looking at these notices of additional allocations. I want to make sure I'm looking at the one from September the 5th. This is what, that I've been going on, which is why I asked for these summary sheets so that we could see the specific alleged violations. When I go to this September 5th, where it's got the amended notice of additional allegations, I'm looking at, A through F under number 3.
Yes, sir.
I mean, do we need to, move on those individually?
So I chose to just make this one violation. If I wanted to, I could, but there's a few reasons why I didn't. Number one, I originally sent her probably 10 or 12 photos, and some of them she was giving explanations for, and if it was a somewhat plausible explanation, I put that aside and said I'm not going to take action with this, number one. Number two, I don't have any records, I don't have financials, I don't have receipts or anything like that, so I don't even know, for instance, the purchase of yard signs. I don't even know, did she pay for that? Did she receive money and pay for it? It's not like I have a bank record where it says she, on May 1st, she spent $5,000. Well, then it's easy when you're doing the violation, you can say, you know, May 1st, she had an expenditure of $5,000, she didn't report it. But in this situation, that was a factor that I considered where I can't even say when things were purchased, what was purchased, and a lot of it is because she violated her statutory duty to keep records of this stuff. The last thing I'll say that I considered, Ms. Jenkins probably has a $1,000 campaign or less. Just looking at the exposure she has on these 5 violations, we've also served the enhanced late fee notice on her, so there's going to be enhanced late fees. So I didn't think this was a complaint, you know, that I needed to be overly pedantic on and charge each individual contribution or expenditure. But that was a decision that I made.
All right, help me out with this then, okay? On the original complaint that was filed,
Yes, sir.
out of the 5 alleged violations that are listed, which ones are covered by that original complaint?
Original complaint is just violations 1 and 2.
All right,
The calendar year 2023 PFDS and the April 30th, 2024 CCDR. Violation 3, and again, when I talked to her, I told her, you need to file, you're gonna have a report date coming up June 30th, so don't miss that. And when we get to July, I, you know, came back from the holiday, and I see she didn't file anything. So then I served the first additional allegations, and that covered,
that's 3, right?
yes, sir, that covered June 30th.
Okay,
And then 4 and 5 originated on September 5th, and that was after I reviewed what she filed. I talked to Ms. Brown and Ms. Jenkins. I asked for, you know, bank records, and it just went radio silent. And then, you know, 3 to 4 weeks after that, I did the second additional allegations. And I think just for brevity, I think I included the June 30th misfiling on the second.
that's what I was gonna check.
Yes, sir.
That's actually just covering the one that was already in the first notice of additional allegations?
Yes,
All right. So 4 and 5, I'm assuming, just come from the September 5th letter?
yes, sir.
And I guess this is the only other thing that I'm just sort of wondering about is if you look at number 3, again, on that September 5th letter, you know, the allegation that we've gotten, you know, the motion that would typically be made would just be what's stated in number 5. But, you know, again, I think since we changed course with the Oxenbaum case and we're naming all of these violations individually, if we, you know, if we just make the motion that's referenced there in number 5, I mean, are we not being specific enough, you know, for the matter when it gets to OSA?
I would just detract from that because I hadn't had any contact with her, so I sent her over everything that I had. And when I was on the phone, she was giving me some explanation, you know, whether something was old or used. But I remember discarding some of the evidence that I had and some of the things that were listed in 5. So I wouldn't take what's listed in the additional allegations verbatim for that reason.
Well, tell me this, because this is what I need to make sure that I'm clear on. What's the evidence that supports violation 5 as it's set forth in the case summary sheet for us?
It's all the Facebook exhibits. So this photo right here showing the 2 campaign t-shirts.
What numbers are those? Because I'm trying to coordinate this back with the September 5th letter. Well, I'm looking at exhibits 1, 2, 3, and 4. I just want to.
Mr. Chairman, I don't have the complaint on me, so I can't answer that question from where I'm at.
Those aren't marked with exhibits over there?
They were marked as exhibits on the additional allegations. When I prepared the PowerPoint,
Oh, he's got it. Where's that?
So the T-shirt here is Exhibit 1 in the complaint.
The right picture?
Yes, the picture on the right. The picture on the left is Exhibit 2.
Okay.
Tim, can you scroll to the one that spells out her name in the block letters? is Exhibit 3. You see this?
Is that in this? Is it in the packet or not?
Yes, I'm on the packet.
All right, so can you click to the one that he's talking about so that I can make sure that all the commissioners see this? It's the one where there are signs, and there's a 1J, then there's an O and an R.
That's something, she told me that was an old photo when she ran for super district in 2020. And I ended up going back on social media on one of her other pages, and I actually found evidence that she was using those t-shirts and that design back in 2020. So that was one of the things that I'm not presenting as evidence here. That's just because after I spoke with her, she gave me an explanation that I was satisfied with.
So Exhibit 4, which is the sign that says vote Joe Ray Jenkins for District 1 Commissioner. So this is Exhibit 3.
So Exhibit 3, she told me.
No, I'm showing you the exhibit so you can show us up there.
Okay, I want the commissioners to be able to see what's Exhibit 1, 2, and 3, so they can coordinate that with the September.
This is going to be 3.
3, now, Exhibit 3 and the additional allegations, she gave me a satisfactory
Okay.
explanation of. So I didn't present Exhibit 3.
Okay.
So when you go back down there, show them that this is 4.
Exhibit 4 is not
And then-
listed.
Okay, what about 5?
5 is this screenshot that you're looking at right here.
So Exhibit 5, as it relates to this violation, is the picture on the right, which would have been a contribution from her previous campaign account.
6 is,
6 is out.
yes, sir. Exhibit 7 is, Exhibit 7 was just illustrative. Exhibit 7 and the additional allegations was listed on the left of this slide.
Okay.
And it was just illustrative to show what her Super District 9 signs look like.
And then go back to the slide you were just on, because that's Exhibit 8. This is Exhibit 8.
And where's our issue there?
This did, there was no photography, no graphic design contributions or expenditures reported.
And then the final exhibit is the meet and greet.
Now, this, I did not include this, but wait a second, not the meet and greet. This photo right here, I didn't include this in the additional allegations, and my original thought process was this is the expenditure that she reported for May 5th, yard signs. So originally I didn't take action with it. It was just gonna be something that I addressed with her. It needs to go on the April 30th CCDR, but I haven't had a lot of luck getting good response from her to do that. So this is something that I just added in for this presentation, but I do, again, you know, this was a conscious decision that I made. Do I wanna just go in and start listing every single violation that I have? Looking at all the factors of this complaint, I made the decision that wasn't appropriate. I would just charge one violation, and if any of these satisfy that prong, that's that violation.
And that's fine, I think as long as we state for the record, you know, for when it actually gets transferred over, that, you know, we're talking about, again, on the September 5th letter, we're talking about exhibits 1, 2, 5, 7, 8 so far.
Yes,
And
sir.
again, that's fine. I'm not saying you did anything wrong, I'm just trying to perfect it for the record. So what about now?
Meet and greet, the sort of artistic looking.
That is on,
It's the one on the right?
yes, sir.
Okay. And that's, again, that's the elect Joe Ray Jenkins meet and greet.
Yes.
And tell us what the issue is with that.
This was posted on Facebook April 24th. Appears to be some photography expenditures, graphic design expenditures, possible print. I don't know if it was printed or not, but it does appear to show some
evidence of campaign spending.
Okay, and again, just for purposes of summary here, when we're talking about what will be the fifth motion that I make, and it's number 3 on the September 5th, 2024 amended notice of allegations. What we're actually talking about as evidence today in support of that violation, we've got 1, 2, 5, 7, 8, and 9. Is that right?
Yes, sir.
Okay. Any other questions or comments for Mr. Baywell, any of the commissioners? All right, I'll go ahead and make the motion. Make a motion that reasonable grounds exist that the respondent violated the Campaign Finance Act by failing to timely file her calendar year 2023 PFDS in violation of OCGA 21-5-50A. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion passes. Make a motion that reasonable grounds exist that the respondent violated the Campaign Finance Act when she failed to timely file her April 30, 2024 election year CCDR in violation of OCGA 21-5-34C2A. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. I'll make a motion that reasonable grounds exist that the respondent violated the Campaign Finance Act when she failed to timely file her June 30, 2024 election year CCDR in violation of OCGA 21-5-34C2A. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. Make a motion that reasonable grounds exist that the respondent violated the Campaign Finance Act when she failed to open and maintain a campaign depository account in violation of OCGA 21-5-30C. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. Make a motion that reasonable grounds exist that the respondent violated the Campaign Finance Act when she failed to report campaign contributions and/or expenditures in violation of OCGA 21-5-34B1 as further clarified in the September 5th, 2024 amended notice of additional allegations and exhibits 1, 2, 5, 7, 8, and 9. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, motion carries. Anything else on that one, Mr. Baywell?
No, sir.
Good job, thank you.
Um,
Somebody?
Former Deputy Director Joe Cusack wants it to be known he agrees with the vote here today because he is watching and can't quit us. And I thought y'all would enjoy that.
You would think the city of Roswell would make their deputy directors literally work for council.
And that was a great presentation.
Yeah, thank you very much. Thank both of you all. Those were all good. Yep. Mr. Thompson?
Mr. Amati, is it not true that in the law, there is a part of the statute that requires any candidate or treasurer to turn over their records upon the request of the commission or any agent?
You mean absent a subpoena or something?
Yeah.
Yes, that's correct. There is a provision in state law that says upon notice of inspection is what it's called.
Okay, so
They have to provide those records to the commission.
can we maybe think about adding that as an additional violation if all these people are deciding to ignore the commission when the records are asked?
What would be the penalty behind that, though? I don't think there's anything specified saying, that that's a violation of some provision of the act. right?
I'll be quite honest, sitting here, I don't know if there's a corresponding penalty with the notice of inspection provision, but that's a fair point to look into, yeah.
I thought any violation of the Campaign Finance Act was subject to $1,000 penalty. I don't know, I'm just.
I think it's spelled out more detailed than that.
Mr. Baywell, you might want to walk over to the thing.
I did look at that issue because I had a complaint where I was weighing whether or not I wanted to charge that and wasn't prepared today to answer the question, but just from what I remember, when I read through the statute, I thought our relief would be filing something in Superior Court and getting an order there, and not that it was a violation of the Campaign Finance Act. That's what I remember from it.
Okay, we're gonna move on to part 4 of the agenda, which are the consent orders. But I'm going to put us in recess for about 5 to 10 minutes, and we'll come back and we'll head to number 4 on the agenda. Meeting back to order. Again, we're moving to number 4 on the agenda, which are the consent orders. Just want to remind everyone, first, that we operate under the Hicks rule on this, so that we're going to vote to approve these one at a time, and then if anyone wants any particular case pulled out separate for, a different vote on that, we can do it. And also, we just want to remind the staff attorneys that we don't need some long presentation with respect to each and every one of these orders. We understand that some may be different than others and may require a little more time than others. But again, I just sort of wanted to throw that out until we've seen the consent orders in our packets.
Yes,
So,
sir.
all right. Mr. Canoe, it looks like you've got A through G, is that right?
That is correct.
All right,
So,
I'm going to go ahead and call the number real quick, and then you do it. So case 23-0037-C in the matter of Patrick Labatt.
yes, so that was, that case was filed on September 6, 2023. There were additional allegations on August 30, 2024. And Patrick Labatt, he was a candidate for Fulton County Sheriff in the 2020 election cycle. He won that election. There were multiple violations that were alleged in the original complaint and additional allegations. I worked with his attorney. They provided our office. There was probably more than 2,000 emails and documents back and forth showing what some of these expenditures were for. Ultimately, we agreed upon this handful of violations that I would describe to the commission right now. They've agreed to a consent order related to not filing a PFDS timely, also failing to disclose his spouse's LLCs. This is a case where his spouse had, I believe it was ultimately a total of 5 LLCs that were involved in this, and he was expending campaign funds to her in various ways related to her being his campaign manager, essentially is what this comes down to. But there were many violations for failure to disclose significant sums of money, where he violated by failing to disclose approximately $72,000 in Zelle transfer payments to his spouse related to her work on the campaign, and also failing to disclose approximately $149,000 in expenditures to Alliance Business Management Group LLC. That is one of the LLCs that his spouse is the owner of. And that was between August 5th of 2022 and September 8th, 2023, that portion of expenditures. He also agreed that he violated for accepting contributions without having filed a Form CUSA, because he accepted contributions in general before having filed that, with regards to how he's receiving funds. He also failed to disclose his fiduciary positions as CEO and CFO of a charity that he ran on his 2022 personal financial disclosure statement. Do you want more details about the case, or just get to the?
Here's what I want. It's, this is for all 3 of you. When you get to the very end, I want to know how many violations they agreed to and the amount of money.
Okay. So ultimately, there were 7 violations on that one. 6 violations for Mr. Labatt in his case, and he agreed to a $42,500 civil penalty, along with 4 late fees totaling $500 for a total penalty he agreed to for $43,000. And that's essentially what he agreed to.
Okay.
Thank you.
Case number 21-0015-C in the matter of Manswell Peterson.
Yes. That case was from 2021. This was a case that came before the commission on December 9th, 2021. And respondent failed to appear was a case Mr. Lane had, former deputy director here. Reasonable grounds were found at that time that he had failed to properly disclose and itemize campaign contributions in excess of $100 from April 14th, 2021 to June 26th, 2021. And essentially what he had done was he had listed an aggregate amount of $318,000 in contributions, each one of those being less than $100. So he didn't just, but that didn't, in fact, he didn't never receive that money. He simply inflated his campaign, but that was his violation for not properly disclosing and itemizing. And this was worked out just prior to an OSA hearing that was scheduled on or about July 31st of this year. And Mr. Peterson agreed to pay, do a consent for $3,000, and he have a payment plan with the commission on that.
How many violations?
One violation,
3,000?
yes.
Mr. Knight?
And I do want to make clear, for anyone who may be listening, this is a lower fine than we would normally have instituted. We took into account some issues he's having, and he was okay with this being part of the order, that he is a disabled veteran with limited means. So we did agree to lower what normally would have been the fine in this case.
Is that under those hardship provisions, or is it not?
It's more discretionary. The hardship provisions relate to the late fees.
And that's correct, and I'm sorry I didn't mention that. That is part of the order, that he's a disabled veteran who does have issues with finances.
Okay. Case number 24-0028-C in the matter of Travis Turner.
That's a third-party complaint filed in February. He was chairman of White County Board. In this particular case, Mr. Turner's violation was that he did not disclose his or his spouse's ownership in LLC they owned. It was called ACT Investments. It's ACTTT Investments. It was organized by the respondent and his wife, each with 50% ownership. There were other allegations I want the commission to know that were raised by a third party, but they're unrelated to anything that we deal with here. Had to do with short-term rentals, nothing that isn't within our purview. He agreed to a consent for $500 civil penalty for violation of the act with the PFDS.
One violation, how
Yes,
much?
$500.
I want one more thing I just thought about. I want to know what the official position is. Next case number is 24-0056-C in the matter of, is it pronounced Bet or Betty?
I think I'm unsure. She goes by Lauren.
Okay. Bet Lauren Wallace. Go ahead.
That is Ms. Wallace was a candidate for Superior Court Judge in Douglas Judicial Circuit. She was successful in that election. She failed to file a PFDS within 15 days of qualifying. That was her violation. She was very cooperative, to remedy the issue immediately after it was brought to her attention. And she agreed to a consent order for a total of $250. That's $125 civil penalty and $125 late fee.
Case number 24-0075-C in the matter of Jack Taylor.
Mr. Taylor, that was also a third-party complaint. He was a candidate for Blue Ridge City Council Post 1, 2021, and was reelected in the 2023 election cycle. He failed to file his 2021 PFDS within 15 days of qualifying and failed to file his 2022 PFDS as well. He resolved this also immediately once it was brought to his attention through the complaint. The consent was, on that case, he agreed to consent $125 civil penalty, $125 late fee, total of $250.
Case number 24-0088-C in the matter of Michael Gordon.
We have, there's an after.
Oh, sorry. Case number 24-0099-C in the matter of Jacqueline Walls.
That's a third-party complaint. It was filed in September 2024. Ms. Walls was a candidate in the special election for DeKalb County Commissioner, District 3. She failed to file her PFDS in a timely manner covering her calendar year. Immediately contacted the office, like these other folks had, receiving the complaint, and resolved that and filed her PFDS. She agreed to a total penalty, $250, which is broken up to $125 civil penalty and $125 late fee.
Now, case number 24-0088-C in the matter of Michael Gordon.
This is a complaint filed by commission staff. Mr. Gordon was a candidate for General Assembly, House District 49 in the 2024 election cycle. He was not successful in his primary. He failed to file a PFDS, his PFDS within 15 days of qualifying as well. That's been resolved, and he agreed to consent to pay a $125 civil penalty. And the reason there's not, before we discussed the consent, he went in and already paid the late fee, so he essentially paid it, but it's not part of the consent because he'd already paid that.
That's it for you, right?
Yes.
Okay. Mr. Baywell?
Position I, Ben Turner, case number 24-0072. Mr. Turner was a candidate for Troup County Sheriff in the 2024 election cycle. He had one CCDR violation, one PFDS violation. He agreed to pay $250 in late fees, $125 in civil penalties, total penalty of $375.
Okay, hold on. Case number 24-0074-C in the matter of Billy Wayne Sharp.
Mr. Sharp, he was the successful candidate for Putnam County Board of Commissioners in the 2022 election cycle. He had two CCDR violations, and he had one violation for failing to spend campaign contributions on ordinary and necessary expenditures. He had $2,700 in his bank account. He zeroed out. He took it on the belief that he was owed from a prior loan. That was mistaken. He had previously paid the loan. He was not indebted to his campaign, and so he took the $2,700. He was cooperative with us and transparent, and from what he said, it was just an honest mistake that he forgot that he had paid himself back. He agreed to pay $250 in late fees, $3,250 in civil penalty, for a total penalty of $3,500.
What happened to the 2,700? Was it returned, or are you putting that in the penalty?
It's part of the penalty that was,
Does that, go ahead. Does that coordinate with the law? Because there's specific things you have to do with your excess funds. Does this fall within what you can use that for?
if he did return it, well, he did dissolve his campaign, so there's not really a place to return it. But in theory, if he did return it, it's usable to pay the penalty.
And that's what I was going to say, was going to be a question that I was going to ask sort of at the end of all of this, but, I mean, there's no longer any campaign funds to pay what he agreed to pay, so all that's technically coming out of private funds.
Yes, sir.
Yeah.
Position K, Coalition for Clean Government.
Well, wait a second now. It's J. I'll call the case number, okay?
Yes, sir.
I know you're trying to be in a hurry, and I appreciate it.
Yes, sir.
Case number 24-0078-C in the matter of Coalition for Clean Government.
This was a commission-generated complaint. The Coalition for Clean Government was an out-of-state LLC, and we saw evidence that they were making political expenditures opposing two candidates for office here in Georgia. We did track them down. They agreed that they were in violation by failing to register with the commission before receiving or spending money for that purpose. Under the law, they had to register as an independent committee. That was their lone violation. They agreed to pay a civil penalty in the amount of $1,000.
Okay, case number 24-0057-C in the matter of Norman Carter Jr.
Mr. Carter's a sitting member of the Snellville City Council. He had 3 CCDR violations. He agreed upon a penalty of $375 in late fees, $125 civil penalty, total penalty of $500.
Case number 24-0067-C in the matter of Daphne Totten.
Ms. Totten was a candidate for Ogeechee District Attorney in the 2024 election cycle. She had one violation, one CCDR violation. This was a third-party complaint that we received. The complaint was sent in the day after the grace period ended for that filing, so we received the complaint. The day after that, she completed the filing already, so in this case, we just assessed a $125 late fee. She essentially missed the filing date by 2 days.
Okay. Case number 24-0076-C in the matter of Angie Arp.
Ms. Arp is a sitting member of Blue Ridge City Council. She had one PFDS violation and one pre-DOI contribution violation. She agreed upon penalty of $125 in late fees, $250 civil penalty, total penalty of $375.
Case number 24-0014-C in the matter of Tammy Andrus.
Ms. Andrus was a candidate for Cobb County School Board in the 2020 election cycle. This is a case that actually went to preliminary hearing at our June 2024 board meeting. After the preliminary hearing, I did talk with her and we were able to reach a resolution on this case. She had one violation for receiving pre-DOI contributions. She also had one violation for failing to terminate her campaign account within 10 days of dissolution. She agreed on a penalty of $125 late fee, $250 civil penalty, total penalty of $375.
Case number 24-0066-C in the matter of Greg Kirkpatrick.
Mr. Kirkpatrick was a candidate for Georgia State House of Representatives in the 2024 election cycle. He had one CCDR violation, one PFDS violation. He agreed to pay $250 in late fees, $250 civil penalty, $500 total penalty.
Case number 24-0090-C in the matter of Elton Alexander.
I'll just preface, there was a mistake on the original consent agreement that I turned over to Ms. Easterwood. It was just with one of the dates that was listed. So the copy that went out in the binder, there was an error on. The actual copy that you have, Mr. Chairman, and you'll be signing is the corrected version.
Okay.
I just listed the error. I listed one of the CCDR violations as being a March 31st violation, which is not even a report date. It was just an error that I didn't catch.
Okay.
But I did make that correction.
Is it signed? The corrected one, is it signed?
Yes, sir, and it'll be presented to you.
Okay.
Just wanted to note that mistake. Mr. Alexander is a current member of Stockbridge City Council. He had 3 CCDR violations. He agreed to pay $375 in late fees, $125 in civil penalties, for a total penalty of $500.
Case number 24-0109-C in the matter of Matthew Montahan.
Mr. Momtahan is a current member of Villa Rica City Council. He had one CCDR violation. He agreed to pay $125 late fee, $125 civil penalty, total penalty of $250.
Case number 24-0111-C in the matter of Danny Carter.
Mr. Carter is a sitting member of Villa Rica City Council. He had one violation. He failed to terminate his campaign account within 10 days of dissolution. He agreed to pay $125 late fee, $125 civil penalty, $250 total penalty.
Case number 24-0114-C in the matter of Shirley Marchman.
Ms. Marchman is a sitting member of Villa Rica City Council. She was successful in the 2019 and 2023 election cycles. She had 2 violations for failing to terminate each campaign within 10 days of dissolution. She agreed upon late fees of $250, $125 civil penalty, total penalty of $375.
Case number 24-0041-C in the matter of Tracy Taylor.
Mr. Taylor was a candidate for Georgia State House of Representatives in the 2022 and 2024 election cycles. Between both campaigns, he had 5 total CCDR violations. He agreed upon payment of $625 in late fees, $375 in civil penalties, for a total penalty of $1,000.
Case number 24-0085-C in the matter of Desmond Brown.
Mr. Brown is a sitting member of the Macon Water Authority. He was a successful candidate in 2022 and 2024. He had 5 total violations, 5 total CCDR violations for both campaigns. He agreed to pay $750 in late fees.
Case number 24-0096 in the matter of Elaine Paget.
Ms. Paget was a candidate for Georgia State House of Representatives in the 2024 election cycle. She had 1 CCDR violation and 1 pre-DOI contribution violation. She agreed to pay $125 in late fees, $375 in civil penalty, for a total penalty of $500.
Thank you, Mr. Baywell. That's all of yours, right?
Yes, sir, thank you.
Mr. McCarter,
Yes, sir.
case number 24-0059-C in the matter of Nadine Thomas.
Ms. Thomas campaigned in the Democratic Party primary for the state Senate seat for the 44th District of Georgia. She failed to file 1 CCDR and also failed to file PFDS. In resolving the matter, we agreed to pay, or she agreed to pay the commission $250 in civil penalties.
Case number 24-0077-C in the matter of Bill Bivens.
Mr. Bivens currently serves as city councilman for the city of Blue Ridge, Georgia. He only has 1 violation. He failed to timely file his 2020 PFDS. In resolving this matter, we agreed to pay $150 in late fees since it was only a couple days late.
Case number 24-0051-C in the matter of Cyrus Colley.
Mr. Colley ran for sheriff of Clayton County for the election year 2024. He failed to file 2 CCDRs and also failed to file his PFDS upon qualifying to run. And in resolving this, Mr. Colley agreed to pay to the commission $375 in civil penalties.
Case number 24-0055-C in the matter of Robert Patillo.
Mr. Patillo ran as a candidate for Superior Court Judge in the Atlanta Judicial Circuit for the 2024 election year. He filed his April 30th, 2024 CCDR, but the contributions within that CCDR did not contain the required information by law in a majority of those entries. And in addition, he also accepted contributions from anonymous sources. So there are 2 violations, and we came to an agreement for him to pay $875 in civil penalties.
And case number 24-0097-C in the matter of Laura Mervarshin.
Ms. Mervarshin ran as a candidate for the Georgia House of Representatives for the 48th district. In this matter, she failed to file a 2-day business report for a primary election, and that was her sole violation. And she agreed to pay $250 in civil penalties to the commission.
One question, backing up one on Patillo.
Mm-hmm.
When somebody makes an or receives an anonymous contribution, are they ultimately disclosed when you rectify?
So how I figured out is an anonymous, they're not putting anonymous, but they're putting, I think one was a wallflower, and they gave no information or anything like that, so there's no name, there's no address, there's no employer, so those are.
But it is ultimately disclosed.
They did disclose it.
It's part of the consent. Thank you.
Technically, what's supposed to happen is you have to return it, but if it's anonymous, then you have to escheat it to the state. But it shouldn't even be reported. There should be a transactional letter that it sends it to the state treasury, and the copy goes to the commission.
Do we have any questions or comments for any of the 3 staff attorneys regarding the consent orders that were just presented? I do want to point out that Mr. Knittel has more cases on the preliminary hearings, but Mr. Baywall has more cases on the consent orders. And so I guess members of the public need to take that into consideration when the case is assigned to whichever attorney, right?
Baywell's nicer than I.
Okay. All right. I'll make a motion with regard to consent orders 4A through 4AA being approved by the commission. Do I have a second?
Second.
You got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? All right, that motion carries. We'll move on to the next. Again, thank y'all very much for everything that y'all done. And Mr. McCarter, I didn't mean to leave you out of that discussion, but perhaps you should try to model yourself after one, or maybe a combination of both of them.
Really nice
Item 5 on the agenda is administrative dismissals. Really, there doesn't have to be any comment on those. Mr. Amati, do you want to address anything with regard to those?
I do not.
Okay. We'll move on to.
I did have one question there.
Sure.
I don't recall the exact one. There's one dismissal where it was based on the candidate had paid the late fee when it was administratively billed to them. And so they get dismissed, which I think is a good result, versus the ones that don't pay it end up in Mr. Baywall's, court for, for consent orders. It just,
That was, just for the record, that was David Rainier's case, which was not my original case. I'm not saying he had it before me, but I caught that and we need to dismiss that.
So, just to clarify,
The point is, that individual had paid the late fee before the complaint came in from the third party.
That is correct.
And
It was
that's
a
why.
third-party complaint, and upon investigation, you
I think
take
that's a
care
good
of it.
result, and I
Yeah.
encourage it.
Sure.
I'm just
Yeah.
noting that if you cooperate with the commission, you get treated here as opposed to Mr. Baywall going after you.
All right, we're going to move to item number 6 on the agenda. It's OSA decisions. Who do we have on that? Who's going to present that?
I'll present that.
Okay.
So,
Go ahead, Mr. Kennedy.
thank you. This is, our case number is 22-0089C. It's in the matter of Khadija Abdur-Rahman. Miss Abdur-Rahman, she was Fulton County Commissioner, District 6. She had ran in the September 2019 special election, lost, and ran again in 2020 and won that election. I believe she ran again this year and also won. But procedurally, this was a case that came out of a preliminary hearing that was held, and the commission found reasonable grounds that the act was violated in several manners. In May 2024, commission, this was referred to the Office of State Administrative Hearings. This was originally set for, a July hearing. It got continued to August 5th, and then again to August 22nd when we actually had the hearing. At that hearing, respondent failed to appear. She didn't have an attorney. Nobody showed up on the other side. That made testimony a little easier on my part, I suppose, but that's what it was. Ultimately, the judge in that case found that Ms. Abdur-Rahman had violated the act in several ways, that she failed to file or timely file 6 election year CCDRs. She also failed to file or timely file 2 non-election year CCDRs. That she had, had accepted pre-DOI contributions, the amount of $2,730.83. That she had failed to disclose 21 campaign expenditures, each of those exceeding $100. And that she had used campaign funds 39 times for purposes other than to defray necessary and ordinary expenses. And I think it's important to note in the judge's decision and what she wrote, and there's some more violations, and I'll talk about those, but the judge noted that this appeared to essentially be that the respondent was using her campaign account as a personal account, converting the funds. So I think that's important to note when we talk about what the ultimate penalty was in this. She also found that the respondent failed to disclose repayment of a $15,000 loan she had made to her campaign. She also failed to report contributions in the amount of $1,142.50, and that she had failed to report contributions in the amount of approximately $40,000 between May 2019 and October 2020. Ultimately, what the judge ordered the respondent to pay was $17,250 in civil penalties, and specifically ordered that that has to come from her personal funds, not campaign funds, and that those can be made through periodic payments at times under conditions agreed to by the commission.
And the message here is that, well, you correct me if I'm wrong, but I'm thinking that language ended up in this order because of the allegations regarding the commingling of funds.
Yes,
So
100%
I think
agree
the
with you.
message to be sent by this is, if you're out there commingling the funds, you are significantly increasing the risk that the fine is going to have to come out of your personal funds as opposed to any campaign funds that may still be in the account, right?
Yes.
Mr. Thompson?
Is it not true that, and during the preliminary hearing, the commission didn't find reasonable grounds to believe the Ethics Government Act may have been violated? They found that it may have been, that it was.
That is more specific language, yes, Vice Chair, may have been. I think I indicated that.
You misspoke?
I believe I may have misspoke, I'm not certain if I did, or Vice Chairman Thompson believes somebody misspoke, though. I'm not sure if it was me, but it could have been.
To Commissioner Denson's question earlier today, in a case where it seems unlikely that someone who's assessed a fine is going to be willing to pay the fine because this person didn't show up to the hearing, didn't show up to the bench trial, that this is an instance where we've already communicated with the AG that we're going to need to institute some sort of garnishment action.
Yeah, Commissioner Benson, again, this would kind of follow up on what we were explaining earlier. This is a case that the decision was filed before the Office of or by the Office of Administrative, in the Office of Administrative Hearings on September the 23rd. I believe the time limit, again, correct me if I'm wrong, but the time limit will be 30 days for the commission to take any type of action with regard to the decision. And in this instance, there was no action taken by the commission with regard to the decision, so it became, automatically final that 30 days after September the 23rd. Again, y'all correct me if I've said anything wrong on that.
That's correct.
Okay. Okay. All right, we're going to move to number 7 on the agenda. It's the report of the executive director. Again, thank you very much for that one, Mr. Kendall.
Thank you, Mr. Chairman. 3 issues I want to address with the board in this report. First is the upcoming legislative session. There are a couple issues that I think we're going to see coming forward in legislation once they gavel back in January. I'll be introducing, along with some partners in the House and Senate legislation, that call us for a few things. First, we're going to be attempting to modernize the filing schedules the campaigns file on. Right now, their reports are due at different times in different years, whether it's an election or non-election year. Candidates for different types of office have different schedules than other candidates. I'd like to see us move more towards the federal model where we have quarterly reports every year, so that it's the same 4 days every year, no matter what you're running for, if it's election or not. I think that is going to make a lot of sense and make this a little easier for everyone to comply that want to comply. We're going to be doing the same as it relates to the financial disclosure reports. Right now they're due based on qualifying election years, and other years through July 1st. In a little bit of humor, we've decided that what actually works best would be April Fool's Day, April 1st of every year. The same date every year, but in election years that still is filed early enough that the public has access to that information before any primary voting would occur. And it's pretty close to the date that they generally have that now in election years. As the vice chairman alluded to earlier, we will be proposing a return of local filings from local counties and cities to the state. I believe we have the support of ACCG and GMA on that. It was an experiment that was decided to be made some years ago, 10, 15 years ago. I think everyone agrees it would be better housed at the state level. We'll also include in that bill that we'll be introducing a redaction of the personal home addresses of candidates for office from public view. We've seen a lot, unfortunately, of swatting and doxing that has occurred. Someone lost their life just in the last week in North Georgia related to a swatting call. And to be clear, these candidates for public office will still disclose where they live to the commission, so that if there's anything that could potentially become a violation of law related to that, we know. But my proposal would be redacting that from public view. I do think we'll see a few other things. Last year, there was a foreign national bill that was passed. There were some issues with that bill and it was vetoed, but I think some corrections will be made, which will require agents of foreign nationals to register with the commission. I suspect there will also be a codified ban on foreign dollars coming into Georgia. That's already currently illegal according to federal law, but I think it's always better to be as explicit as we can. And then the third big thing, I think, and you know, predicting session is a crapshoot, but the third big thing I think we know we'll see is a bill regarding generative artificial intelligence. There was a bill last year. I worked with Chairman Thomas in the House. I've talked with Chairman Thomas and Senator Albers in the Senate, and they're working collaboratively on that deals with generative AI that is deceptively used in campaign content. And I'm not going to sit here and proclaim to know exactly what we need to do, but I know we need to do something. Those are the three legislative packages I know we'll see. You know, we'll see what else comes down the pipe as we get closer to session. Education initiative updates. Haley Barrett, who runs our education division, has been doing a fantastic job with our great trainers. Just this week, we served on a panel at Biennial in Athens that I think was pretty well received for the most part. Shortly after that, I actually went down and spoke to the newly elected DAs and Solicitors General and had an educational presentation there as well that I know they appreciated. And we have a robust 2025 education agenda coming forward. Lastly, a couple of staff updates. I'd like to introduce Gio Pinson-Rojas on our staff, who joined us recently, as well as a return to the staff, another paralegal, LaTanya Corbin, who worked here for a few years, and we're really excited to get her back. So those are the two new additions to the campaign staff I wanted to make y'all aware of.
Any questions, comments for Mr. Armani? All right. Item number 8 on the agenda is a report from the Attorney General's office. We see that Ms. Young's not here, so go ahead and identify yourself if you would.
Of course, yes. My name is Danny Yu. I'm with the Attorney General's office.
Yeah, go ahead.
There.
Sure.
Thank you, Commissioners. As stated, my name is Dana Yu. I'm with the Attorney General's office. Now, typically, Beth Young would be here to give the report, but she's out today because she's attending her son's graduation, so I'll be giving the report today. So I'll turn first to the administrative enforcement cases. Some of the cases that our office has been handling have already been reported on by the Commission staff. Those would be 2 that I have marked here are the Peterson matter and the Abdur Rahman matter. Otherwise, since the Commission's last meeting, our section has been extremely busy with elections-related litigation, some of which required extremely expedited briefing schedules. And therefore, because of that and the nature of elections litigation generally, those had to be prioritized over the enforcement cases that our office has before the Commission and other agencies and boards. But fortunately, we are seeing that type of litigation is largely wrapping up now, so we'll be able to turn to prioritizing setting some of these enforcement cases for hearings. Now, turning to other litigation matters, there actually has been activity in the other 2 federal cases since the commission's last meeting. And just a bit of background, I'll speak first about the New Georgia Project case. Since the commission has last met, the 11th Circuit has issued a favorable opinion in that case. And just as a background, that case involves challenges to the commission's regulation of organizations that raise and spend money advocating to elect candidates or to advocate for ballot initiatives. That matter was referred to our office for prosecution claims that this organization should have registered with the commission and also disclosed contributions and spending expenditures. Now, this is an organization that does engage with general get out the vote initiatives, but during the 22 election cycle, there was evidence that they made expenditures in direct support for Democratic candidates, as well as supporting a Gwinnett ballot initiative. And then so shortly after the matter was received by our office, the New Georgia Project filed suit in district court alleging that the state's laws regarding independent committees and ballot committees were unconstitutional because they didn't contain a major purpose requirement. Some courts in other jurisdictions have said these types of laws should only apply to organizations where campaigning is their major purpose, but our jurisdiction hasn't answered that question quite yet. So the district court in that case granted New Georgia Project's motion and entered an order enjoining the enforcement of those laws. We did appeal to the 11th Circuit, and the 11th Circuit agreed with us that the district court should not have exercised its jurisdiction in that matter because there was a pending administrative hearing. And so the 11th Circuit has essentially returned it back to OSA, where there's an administrative order staying the case until January 10th, which I believe gives the parties some time to determine if they're able to present a proposed consent order before the commission. And if not, then we'll expect that the court will set a hearing in that case sometime in early 2025. And now turning to the Graham or Libertarian Party case versus the commission, we had also received favorable rulings in that case from both the 11th Circuit and the district court. The 11th Circuit essentially dismissed the appeal as moot because in that particular case, the Libertarian Party filed suit along with their candidate for lieutenant governor, which is a race that occurred in 2022. And so the 11th Circuit dismissed the appeal as moot because that election had already occurred. And this is an opinion that was issued in August of this year. And so at that time, when the 11th Circuit remanded essentially back to the district court, the plaintiff's counsel attempted to revive the case by attempting to amend their complaint. But the district court, in an order that was issued December 5th, agreed with our position, which is that the 11th Circuit's ruling is final, and so dismissed, or denied both the petitioner's motion and also dismissed the case entirely. And that is all I have. So if there are any questions, I can take them, or I can...
Yeah, and go ahead. If you don't know the answer to this, it's perfectly fine.
Okay.
Do you know how many enforcement cases we do have at this point that are in front of OSA?
I'm not aware of
Okay.
off the top of my head. Sorry.
Okay, that's fine, I was just, checking.
Yeah.
We can find out about that, that's all okay. Any other questions or comments?
Two, the New Georgia case
Yes.
is back to OSA to figure out, that's where that stands procedurally?
I believe so, yes.
And this is another one you may not know the answer to because it's about a case that doesn't exist. I know the state Democratic Party sued the governor about leadership, campaign committee, and didn't sue us.
Right.
I think, as I recall, the case was dismissed because because he was the wrong party. Has the case been filed against the commission that you know of?
I'm not aware if that file has been, or that suit has been refiled against the commission.
And you haven't been served?
I'm trying to pull up I have some knowledge of this. Yeah, so in September, I believe it was Judge Cohen rejected the challenge.
Right.
And there's been nothing refiled in the alternative styling since.
I just recall he mentioned the commission should have been the proper party, and
Right.
we're not,
We have not received anything.
okay.
Anything else?
The only other, just clarification
Sure.
as it relates to the sort of factual background of the New Georgia case, that actually involved the 2018 statewide cycle,
Oh.
not 2022,
Okay.
and then 2019. Okay, thanks.
All right, thank you very much.
Thank you.
We'll move on to item number 9 on the agenda, which is confirming the dates for the 2025 quarterly meetings. Mr. Amani?
Okay, so I'm gonna ask everyone to get their calendars out, make sure these dates work.
Electronic.
So we'll have 4 regularly scheduled commission meetings at this time. Obviously, we have special commission meetings that come up from time to time, but these are the 4 we're gonna block out for 2025. The first one will be in March, and it'll be here in Atlanta. And the date I'm proposing is Wednesday, March 19th for that date. Alternatively, if that doesn't work, we could do Thursday, the 20th.
Can you not do it the week after?
No,
Why?
I don't want to get into Sunny Day. I know it won't be Sunny Day that week.
That's fine.
So Wednesday, March 19th, does anyone have an issue with that date?
More than likely, I will not be able to make that one.
You gonna be somewhere where you could attend it,
Actually,
virtual?
Maybe.
okay.
I mean, that's an option, we can make it.
All right, our second meeting will be in June, and it'll be in Commissioner Denson's hometown, Athens, Georgia. And I'm proposing Thursday, June 12th.
Okay.
All right. Our third meeting, quarterly meeting, will be in the chairman's hometown of Savannah, or his neck of the woods, I should say. And I'm proposing that the September meeting be Thursday, September 18th in Savannah. All right,
I have a conflict there.
okay, what about the 25th or the 26th?
No, after that, I could do earlier in the week without any problem.
Okay, can we do Wednesday?
Yes,
Okay, so we'll make that Wednesday, September 17th, and what we'll do is we'll just flip the training in Savannah to the 18th. Okay.
thank you.
So Wednesday, September 17th in Savannah, down on the coast. And finally, I didn't write down what day of the week it is, but in December, we'll be back here in Atlanta. And I'm proposing December 4th. Is that a Thursday? Okay, Thursday, December 4th. And with that, I think we have our quarterly date set.
What was the call on March
19th, Wednesday.
Can that,
It'll be back here in Atlanta.
for that Atlanta date, I guess when else could we do that?
When do you get back? When are you, you got Vincent Park?
I mean, I'd definitely be back in April. If we wanted to push it, that's too far away.
Yeah.
Just do it, I'll figure it out.
Well, we'll vote it in.
Do you have conflicts?
No, what about earlier is not gonna do you any good, is it? Yeah, that's right. I mean, what about like right toward the end of the month? I mean, that would be better,
That's a
right?
problem, because it's so.
Sorry, you
I know.
So, you know,
All right, just leave it there for now.
I've got a hard date when I go back,
Okay.
sure.
So those are the dates. If there are any changes to those dates, we can communicate and communicate that to the public as well. So we leave that option open.
Okay. All right. Public comment? Anyone here for public comment today? No? All right. Next thing is executive session. To discuss what's referred to here as legal matters, do I have a motion to adjourn into executive session?
So moved.
Second?
Got a motion and a second, any discussion? Hearing none, I'll call the question, all in favor say aye. Aye. Any opposed?